Hello everyone. Today we are going to solve a few most important MCQs on company law. So those who are preparing for All India Bar examination this year, this video lecture will be very helpful for you all. Hey everyone, my name is Sangeeta. Welcome back to this channel. Be legally aware. So without any further delay, let's start today's session. So the first question is our which amongst the following is not a characteristics of a company? Which of the following is not a characteristics of a company? A very important question. Let's see the options. Options are separate corporate personality, option B common seal, option C unlimited personal liability, and option D perpetual succession. Okay, so in this case the correct option would be option C. That means unlimited personal liability is not the characteristics of a company, but separate corporate personality, this is it is a characteristics of a company. Common seal, it is also a characteristics of a company. Perpetual succession, it is also a characteristics of a company, but unlimited personal liability is not a characteristics of a company. Okay, so in this case the correct option would be our option C. Okay, so that means unlimited personal liability is not the characteristics of a company. Okay, so now moving to next question. So the next question is our what is the legal position of a promoter? Very important question. What is the legal position of a promoter? So options are option A trustee to a company, agent of a company, fiduciary relationship to the company, and the last option is master servant relationship to the company. So in this case the correct option would be our option C, that means fiduciary relationship to the company. That means the legal position of a promoter is of fiduciary relationship to the company. Okay, so in this case the correct option would be option C. So what do you mean by promoter? A promoter is a person who establishes a company and who takes on necessary action to incorporate it as a to corporate it as a separate separate legal entity. So promoter is a person who establishes a company and takes on necessary actions to incorporate it as a separate legal entity. Okay, so now moving to the question, what is the legal position of a promoter? So in this case the correct option would be option C, that means fiduciary relationship to the company. So in this case the correct option would be option C. Okay, so now moving to next question. So the next question is our which among the following is the leading case for the doctrine of indoor management? Very important question. So let's see the options. Options are option A Royal British Bank versus Tarquant 1856, option B Solomon versus Solomon 1897, option C Foss versus Harbottle which is of 1843, and so the next option is option D, that is Ashbury Railway Carriage and Iron Company Limited versus Rich, which is of 1875. So in this case, the correct option would be option A, that means Royal British Bank versus Tarquant of 1856. So this is the leading case, leading case of the doctrine of indoor management. Okay. So in this case, the correct option would be option A. Okay, so now moving to next question. So the next question is our minimum number of directors. Very important question. Minimum number of directors in a public company shall be. Let's see the options. Option A 3, option B 2, option C 7, and option D 15. So in this case, the correct option would be our option A. That means number 3. That means minimum number of directors in a public company is our number 3. But in case of private company, it would be number 2. It would be number 2. That means minimum number of directors. That means in case of private company, the minimum number of directors is 2, but in case of public company, the minimum number of directors is 3. So in this case, the correct option would be our option A. Okay, so now moving to next question. So the next question is our where fraudulent or dishonest use is made of legal entity, the individuals concerned will not be allowed to take shelter behind the corporate personality. The court shall break through the corporate shell, and this is called as the options are. Let's see the options. Options are doctrine of constructive notice, doctrine of alter ego, of lifting doctrine of lifting up of the corporate veil, and the last option is doctrine of indoor management. So in this case, the correct option would be option C. That means doctrine of lifting up of corporate veil. This is very important question. So in this case, the correct option would be option C. Okay, so now moving to next question. So the next question is our document that regulates the management of internal affairs of a company. Very important question. Let's see the options. Options are memorandum of association, articles of association, option C prospectus, and option D certificate of incorporation. So in this case, the correct option would be our option B. That means articles of association, which is commonly known as AOA. That means article of association. That means articles of association. So articles of association is the document that regulates the management all the internal affairs of a company. ओके दैट मीन्स एक कंपनी का जितना भी इंटरनल अफेयर्स होता है वो कौन सा डॉक्यूमेंट रेगुलेट करता है, वो आर्टिकल्स ऑफ एसोसिएशन ऑफ द कंपनी रेगुलेट करता है. सो इन दिस केस द करेक्ट ऑप्शन वुड बी आवर ऑप्शन बी. ओके दैट मीन्स आवर आर्टिकल्स ऑफ एसोसिएशन. दैट मीन्स कोई भी एक कंपनी अगर है एंड उसका जितना भी इंटरनल अफेयर्स होता है सब कुछ का रेगुलेट कौन करता है, आर्टिकल्स ऑफ एसोसिएशन. एंड मेमोरेंडम ऑफ एसोसिएशन विच इज नोन एज MOA. This is also important document of a company. Okay, so in the earlier video I have differentiated between memorandum of association एंड आर्टिकल ऑफ एसोसिएशन. सो आप लोग जाके प्लेलिस्ट में देख सकते हैं. ठीक है. सो नाउ मूविंग टू नेक्स्ट क्वेश्चन. नेक्स्ट क्वेश्चन इज आवर if A Limited has a right to appoint majority of board directors of B Limited, then A Limited shall be considered as that means देखिए that means अगर एक ए लिमिटेड कंपनी है एंड उसका राइट है टू अपॉइंट मेजोरिटी ऑफ द बोर्ड ऑफ डायरेक्टर्स ऑफ बी लिमिटेड. दैट मीन्स ए लिमिटेड एक कंपनी है एंड बी लिमिटेड एक दूसरा कंपनी है एंड देन ए लिमिटेड शेल बी कंसिडर्ड एज. दैट मीन्स ए लिमिटेड कंपनी के पास वो इतना पावर है कि वो अपॉइंट कर सकता है मेजोरिटी ऑफ द बोर्ड ऑफ डायरेक्टर्स ऑफ बी कंपनी. सो इन दिस केस ए लिमिटेड कंपनी को क्या बोला जाएगा. ओके सो लेट्स सी द ऑप्शंस. So the options are subsidiary of B Limited company, holding company of B Limited company, option C associate company of B Limited, and option D none of the above. So in this case the correct option would be our option B. That means holding company of B Limited. Okay, that means in this case ए लिमिटेड कंपनी को बोला जाएगा कि होल्डिंग कंपनी ऑफ बी लिमिटेड. दैट मीन्स ए लिमिटेड will be considered as will be considered as holding company of B limited. Okay, so in this case the correct option would be our option B. Okay, so now moving to next question. So the next question is our a petition under section 272 for winding up of a company by tribunal cannot be filed by. Let's see the options. Options are option A, the company, option B, the contributory, option C, the registrar, and option D, the unsecured creditors. So in this case, the correct option would be our option D. That means unsecured creditors. That means a petition under section 227 for winding up. So what is winding up? Winding up means closing process of a entire company. सो विंडिंग अप हम लोग किसको बोलते हैं? कंपनी उसका क्लोजर हो जाता है तब उस एंटायर प्रोसेस को हम लोग बोलते हैं विंडिंग अप. ओके, सो विंडिंग अप ऑफ ए कंपनी बाय अ ट्राइब्यूनल कैनॉट बी फाइल्ड by the unsecured creditors. Okay, so in this case the correct option would be our option D. Okay, option D. Okay, so now moving to next question. So the next question is our the following statement is not correct as regards a company. Let's see the options. Option are it is an artificial person, it is not a citizen, it does not have the perpetual succession, and it can sue and be sued. So in this case the correct option would be our option C. That means it does not have a perpetual succession. That means it is an artificial person. It is a correct statement as regards a company. It is not a citizen. It is also correct as regards a company. It can sue and be sued. It is also correct as regards to a company. But it does not have a perpetual succession. This is not correct because a company has a perpetual succession. Because a company has a perpetual succession. Okay, so in this case the correct option will be our option C. Okay, so now moving to next question, and this is the last question. Next question is our the doctrine of indoor management. The doctrine of indoor management has its genesis in, let's see the options. Options are Ashbury Railway Carriage Company Limited versus Rich. Option B, Royal British Bank versus Tarquant. Option C, Salmon versus Salmon and Company Limited. And the option D, Daimler Company Limited versus Continental Tire versus Rubber Company Limited. So in this case, the correct option would be option B. That means Royal British Bank versus Tarquant. So the doctrine of indoor management has its genesis in Royal British Bank versus Tarquant. So in this case, the correct option would be our option B. Okay. So this is for all today. If you like this lecture, please like this video and please don't forget to subscribe this channel. Till then, take care. Bye bye. See you in the next video.